unsubstantiated statement that the legislators have gone incommunicado cannot even be a ground to attract disqualification under paragraph 21A of the 10th schedule. When rival factions emerge in a political party, especially within the leadership, it is possible for both the factions to allege that the other faction has gone incommunicado. In such a circumstance, especially in the light of the law laid down by the apex court in Subhash Desai Supra, it would not be correct to hold any faction to have incurred disqualification for going incommunicado without first determining which of the faction is the real political party, reflecting the will of the political party. Also, having held that the Shinde faction was the real political party when the rival factions emerged, the submission of the petitioner that the respondents have gone incommunicado ceases to hold any meaning for the purpose of disqualification. On the 20th of June 2022, elections for the Legislative Council were held. In his cross-examination, Shri Sunil Prabhu, PW1, stated that all the MLAs were present for the same. In the face of this evidence, it would not be possible to accept that the legislators had gone incommunicado. Respondents have placed that they have been in touch with the UBT faction. They substantiated it by stating that Shri Milind Narwekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents on 21st June 2022 on the instructions of Shri Uddhav Thackeray. This fact was not denied by the petitioner, Shri Sunil Prabhu, when a suggestion was put to him in the cross-examination. In fact, the petitioner admitted that Shri Milind Narwekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents. Also, three of the witnesses for respondents have testified that Shri Milind Narwekar and Shri Ravindra Phatak, MLC, of the UBT faction, had gone to Surat and met Shri Eknath Shinde and other respondents. On 21st June 2022, on the instructions of Shri Uddhav Thackeray, the testimony stood the test of cross-examination and the petitioner could not establish otherwise. Thus, on this count alone, or this count also, it would not be possible to accept the legislators were incommunicado, Whether the deliberate absence of the respondent in the SSLP meetings purported to be held on 21st June 2022 attracts disqualification under paragraph 21A of the 10th schedule. The second ground on which the disqualification is sought is that the respondent deliberately remained absent in the SSLP meeting held on 21st June 2022. Petitioners relied on the attendance sheet register of the meeting dated 21st June 2022. After having considered the submission advanced on this ground, I hold that respondents cannot be held to be disqualified on this ground. In view of my conclusion that 1. The Shinde faction was the real political party when factions emerged, and 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment the faction emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 is liable to be rejected. Irrespective of the conclusion that may be reached about which faction was the real political party, respondents could not be held to be disqualified on the ground that they deliberately remained absent in the SSLP meeting held on 21st June 2022. This is because of the following reasons. Petitioner relied upon the attendance sheet of the 21st of June 2022 to claim that all those MLAs who were signed the said attendance sheet were present in the meeting, while those who did not sign were not present. Based on this document, the UBT faction claimed that respondents remained deliberately absent. A comparison of the original attendance sheet produced along with the affidavit in lieu of chief examination of the petitioner Shri Sunil Prabhu, PW1, with the copy of the attendance sheet produced and verified as a true copy along with the petition, reveals that the two do not match. There are glaring discrepancies. The copy claimed to be the original of the said attendance sheet has a handwritten date of 21st June 2022, whereas the copy verified as the true copy of the original produced along with the petition does not have it. Further, Sri Sunil Prabhu stated in his cross-examination that the documents relied as the attendance sheet was in fact a register of MLAs to whom the whip of 21st June 2022 was served and received. So, facts show: 1. There are glaring discrepancies in the said attendance sheet. 2. The statements of Sri Sunil Prabhu shows the document relied upon as attendance sheet of MLA present on 21st June 2022 is in fact a register of service and receipt of the whip dated 21st June 2022 of the MLAs. Thus, the said document is unreliable and cannot be taken as proof of non-attendance of respondents in the meeting held on 21st June 2022. Hence, on this count as well, petitioner's case that the respondents are liable to be disqualified for non-attendance of the meeting dated 21st June 2022 has to be rejected. Further, all the respondents have denied the receipt of any whip for attending the meeting on 21st June 2022. Countering this, petitioner Shri Sunil Prabhu, in his affidavit in lieu of examination in chief, stated that the whip for 21st June 2022 meeting was sent via WhatsApp by Shri Manoj Harishchandra Chaugle to Shri Prabhakar Kaye, PA of Shri Eknath Shinde. In the cross-examination of Shri Sunil Prabhu stated that the whip was sent via WhatsApp to all the respondents, who according to him were not traceable. However, petitioner has not offered any statement or any material to even suggest that such WhatsApp messages were sent to other respondents. Thus, the petitioner has failed to establish that whip/notice was served upon the respondents in petition number 2/15, directing them to attend the meeting on 21st June 2022. As to the service of whip on Shri Eknath Shinde, the only material produced by the petitioner is an alleged screenshot of the WhatsApp message sent by one Shri Manoj Harishchandra Chaugle to one Shri Prabhakar Kaye. This does not constitute proof of any notice whip was served upon Shri Eknath Shinde, directing him to attend the meeting on 21st June 2022. Further, a perusal of the aforementioned WhatsApp message allegedly sent to the PA of Shri Eknath Shinde shows that the said message was sent at 12:31 p.m. on 21st June 2022 for a meeting which was allegedly scheduled for 12:30 p.m. Thus, it is abundantly clear that none of the respondents were ever served any notice whip for the alleged meeting dated 21st June 2022. Hence, on this ground alone, also, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 21st June 2022 must be rejected. The third ground on which the disqualification of respondent is sought is that the respondents deliberately remained absent in the SSLP meeting held on 22nd June 2022. Petitioner relied on the attendance sheet register of the meeting dated 22nd June 2022. After having considered the rival submissions, I hold that respondents cannot be held to be disqualified on this ground in view of my conclusion that 1. The Shinde faction was the real political party when rival factions emerged. 2. Shri Sunil Prabhu ceased to reflect the will of the political party from the moment rival factions emerged. Thus, it would not be correct to say that Shri Sunil Prabhu had any authority to call any meeting of the SSLP. Hence, on this ground alone, petitioner's case that the respondents were liable to be disqualified for non-attendance of the meeting dated 22nd June 2022 must be rejected. Again, even if I was to take different view about which faction was the real political party, still the respondents could not have been held disqualified on the grounds that respondent deliberately remained absent in the SSLP meeting held on 22nd June 2022 for the following reasons. I am unable to accept the petitioner's submission that non-attendance of the SSLP meeting would make the respondents liable to be disqualified under paragraph 2, 1A of the 10th schedule. I am of the view that non-attendance of party meetings, including legislature party meetings, would not attract disqualification under paragraph 2, 1A of the 10th schedule of the Constitution. Such an action cannot indicate that the members have voluntarily given up his membership of the political party. Not attending party meeting and voicing a difference of opinion outside the House are matters between the members and his party and have nothing to do with clause 2(1)(a) of the 10th schedule. Non-attendance of the meeting can at the most be termed as an act of dissent within the party. If viewed as a form of expression, it would be protected by freedom of speech and expression, which includes dissent and is not only an integral part of fundamental rights under Article 14, 19 and 21 of the Constitution, but is an aspect of the basic structure of the Constitution also. Therefore, even if the alleged non-attendance is seen as an expression of dissatisfaction, it cannot be treated as conduct attracting